Welcome to EUPrivacyForAll, Session 62 on GDPR, Tasks of the EDPB, Article 66. The European Data Protection Board tasks were framed by Article 66. European Parliament suggested additional inputs, such as providing opinion to the lead authority, to the Commission's when delegated and implementing acts are to be adopted, on code of conduct, certification, maintaining a public electronic register on valid and invalid certificates, assistance to DPAs, regarding prior consultation, establishing and making a public list of the processing operations subject to it, maintaining a registry of sanctions. Additionally, it laid down that the EDPB shall, where appropriate, consult interested parties and give them the opportunity to comment within a reasonable period. The EDPB shall also be entrusted with the task of issuing guidelines, recommendations and best practices for investigating and lawful processing. On its side, EU Council suggested that the European Data Protection Board would monitor and ensure the correct application of the GDPR, draw up guidelines for DPAs and fixing of administrative fines, referred also to codes of conduct, certification and accreditation of certification bodies, give the Commission an opinion on the level of protection of personal data in third countries or international organizations, which is new, and maintain a publicly accessible electronic register of decisions taken by DPAs and courts regarding issues dealt with in the consistency mechanism. In its final draft, Article 66, which is 3 pages long, lays down that the European Data Protection Board shall ensure the consistent application of this regulation. That is to say that EDPB shall, on its own initiative or, where relevant, at the request of the Commission, carry out the following missions: monitor and ensure consistency mechanisms without prejudice to the tasks of national supervisory authorities, advise the Commission on issues related to the application of the regulation, advise the Commission regarding the application of binding corporate rules, issue guidelines, recommendations and best practices, notably on the deletion and right to be forgotten implementation, examine on its own initiative or on a request of one of its members or on a request of the Commission the application of this regulation. It shall also issue guidelines, recommendations and best practices regarding profiling, the notification of personal data breaches, high risks for the rights and freedoms of the individuals, justifying communication to data subjects regarding data breaches, criteria and requirements for data transfers based on binding corporate rules, and transfers based on derogations for specific situations. Recommendations of EDPB should also target the supervisory authorities regarding the fixing of administrative fines. It shall review the practical applications of guidelines regarding GDPR and those fines. Guidelines, recommendations and best practices should also frame common procedures for reporting by individuals of infringements of the GDPR, encourage the drawing up of codes of conduct and certification mechanisms, frame the accreditation of certification bodies, maintaining a public register of accredited bodies and of the accredited controllers or processors, specify the requirements mentioned regarding the accreditation of certification bodies, and give the Commission an opinion on certification requirements. It shall give the Commission an opinion on icons and symbols used to inform data subjects, and also on the assessment of the adequacy level of a country or an organization. shall issue opinions on draft decisions of the DPAs pursuant to the consistency mechanism, promote cooperation and effective bilateral and multilateral exchange of information and practices between DPAs, promote common training programs and facilitate personal exchanges. It shall also promote the exchange of knowledge and documentation on data protection legislation and practices with data protection authorities worldwide, issue opinion on codes of conduct drawn at EU level, maintain a publicly accessible electronic register of decisions taken by DPAs and by courts as suggested by EU Council in the frame of the consistency mechanism. When the Commission requests advice from the EDPB, it may indicate a time limit. The EDPB has the obligation to forward its opinions, guidelines, recommendations and best practices to the Commission and makes them public. The EDPB, finally, shall, where appropriate, consult interested parties and give them the opportunity to comment within a reasonable period, and make the results of such a consultation public. However, defining interested parties remain a question mark. Currently, Article 30 of the Directive on Sanctions lays down that the working party shall examine any question covering the application of the national measures adopted under the Directive. It shall also give the Commission an opinion on the level of protection in the community and in third countries, advise the Commission on any proposed amendment of the Directive 95/46, and give opinion on codes of conduct drawn up at EU level. If the Working Party 29 also finds that divergences are likely to emerge and affect the equivalence of protection from a member state to another, it shall inform the Commission. On its own initiative, it can make recommendations on all matters relating to data protection, and its opinions and recommendations shall be forwarded to the Commission and the Article 31 Committee. The Commission, on its side, shall inform the Working Party of the action it has taken in response to its opinions and recommendations, doing so in a report, also forwarded to European Parliament and the Council. The Working Party shall draw up an annual report that will be made public. What should accountable data controllers and processors get prepared for? First, knowing that European Data Protection Board replacing Working Party 29 will have to ensure the consistent application of the GDPR, and that is to say, carrying out the following tasks. First, advise EU Commission on several topics, that is to say, on GDPR, basic implementation, BCRs, and certification, icons used to inform data subjects, and adequacy decisions. It will also have to issue a set of guidelines, recommendations, and best practices on the general implementation of the GDPR, on the right to be forgotten, profiling, data breaches notification to DPAs, and communication to data subjects, transfers based on BCRs and specific derogations, individual reporting of infringements of the GDPR, and fixing of administrative fines. It will also have to monitor consistency mechanisms and issue opinions on DPA's drafts in this frame. It will therefore, more concretely, will have to promote DPA's exchanges of information and training programs. Maintaining a publicly accessible electronic register of decisions taken by the data protection authorities in EU and courts on issues dealt within the frame of the consistency mechanism will be a core task for the EDPB. It will also have to carry out the accreditation of certification bodies in the frame of Article 39 and maintain a public register of both accredited bodies and accredited controllers and processors. It will have to encourage the drawing up of code of conduct and finally publicly organize consultation of interested parties where appropriate so that they could share their comments. So the key question triggered here is how to define the interested parties, and when will it be deemed it is appropriate to consult those interested parties.